19 states. That is the number floating around in video titles claiming assault weapons just became illegal nationwide because of some sweeping Supreme Court fallout, a number that shows up attached to a new month in the title every few weeks, recycled again and again without anyone apparently checking it against the actual statutes. Here is the actual number, verified against the real statutes currently on the books, state by state, as of this recording. Roughly 11 to 14 states plus Washington, D.C., depending on exactly how you count a couple of borderline cases, actually have anything resembling a comprehensive assault weapons ban right now, not 19. And it has nothing to do with a Supreme Court ruling that already happened, because no such ruling exists yet. No such ruling has been argued, and no such ruling is expected for close to a year. What is actually true, and what is actually about to determine the fate of every one of these state laws at once, is a real Supreme Court case the justices only agreed to hear a few weeks ago. Let me walk you through the real list, the real legal status of each one, and the real case that is about to settle this for the entire country. Quick thing before we get into it. I check every claim in these videos against the actual statutes and actual court filings before I put it in a script, not against whatever number is trending in someone else's title. If that is useful, subscribe and turn on the bell, because I am going to keep correcting this specific misinformation as it keeps recirculating with a new month slapped on the title. 2 seconds, and let's get into the real list. Let's start with the states that have what gun law researchers generally classify as comprehensive assault weapons bans, meaning the law restricts the sale, transfer, or possession of an entire defined category of semi-automatic firearms, not just a narrow feature or accessory. California, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, and New York make up the core, long-standing group, several of these dating back to the 1990s in some form, well before the modern era of Second Amendment litigation that followed the Supreme Court's individual rights ruling in Heller back in 2008. Meaning these are some of the oldest, most heavily litigated firearm restrictions currently on the books anywhere in the country. Washington State added its own ban in 2023. Colorado added a version of its own the same year, following the Club Q shooting in Colorado Springs, a mass shooting at an LGBTQ nightclub that became a direct legislative catalyst the way several other state bans trace back to a specific triggering event in their own history. Rhode Island and Maine both added their own restrictions more recently, expanding the list further and reflecting a broader wave of state-level action even as federal legislation on this exact question has repeatedly stalled in Congress. And this year, Virginia became the newest addition, when Governor Abigail Spanberger signed Senate Bill 749 into law in May, banning specific semi-automatic firearms and high-capacity magazines effective July 1st, following 4 consecutive years of similar bills passing the Virginia legislature only to be vetoed by the previous governor. Washington, D.C. maintains its own separate ban as well, technically outside any state's jurisdiction but functioning the same way in practice for anyone living there. Add that up and you get somewhere between 11 and 14 states plus D.C., depending on exactly how strictly you define comprehensive versus partial restrictions, and depending on whether you count a state like Virginia, whose brand new ban is currently blocked by court injunctions and not actually being enforced anywhere in the state right now, even though it is technically still on the books. That is a meaningfully different number than 19, and the gap between the real number and the inflated one matters, because it tells you something about how a piece of content ends up with a headline that sounds dramatic but does not survive even a basic fact check against the actual statutes. It is worth asking where a number like 19 even comes from in the first place, since it does not match any credible legal tracker, any state legislature's own count, or any court filing anywhere in this entire body of litigation, and the honest answer is that it appears to simply be recycled from one piece of content to another, gaining a false sense of authority through repetition rather than through any actual verification against the underlying statutes. Now here is the detail that actually determines whether any of these bans survive going forward, and it has nothing to do with a ruling that already happened. On June 30th, 2026, the Supreme Court agreed to hear 2 consolidated cases, Viramontes versus Cook County out of Illinois and Grant versus Higgins out of Connecticut, specifically to decide whether the Second and 14th Amendments protect the right to possess AR-15 platform rifles and similar semi-automatic firearms. This is the first time the Supreme Court has ever agreed to answer that question directly and nationally after years of lower courts reaching inconsistent results and the court itself repeatedly declining similar opportunities in years past, including a notable 2025 denial in a case called Snope versus Brown that left this exact question unresolved for another full year. Oral argument is expected this fall, and a decision is expected by June of 2027. Nothing about this cert grant changes any current law. Every single one of the bans on the list I just walked through remains fully in effect and fully enforceable in its own state right now, exactly as it was the day before the court agreed to hear the case. What changed is that, for the first time, there is now a clear, roughly year-long timeline pointing toward a single, nationwide answer, instead of a patchwork of state-by-state litigation that could have dragged on for years with no unified resolution in sight, each state's own case working through its own circuit, on its own separate schedule, indefinitely. It is worth understanding exactly how these state laws actually work, because they are not all built the same way, and the differences matter if you are trying to figure out whether something you own or want to buy is actually covered. Most of these states use one of two legal approaches, sometimes both layered together. The first is a named model list, where the statute literally names specific rifles, the AR-15, the AK-47, and so on, along with close variants, an approach that has the advantage of clarity, but the disadvantage of potentially missing new models, manufacturers designed specifically to avoid the named list. The second is a feature-based test, where any semi-automatic rifle that accepts a detachable magazine and has one or more specific features, a pistol grip, a folding or telescoping stock, a flash suppressor, a threaded barrel, gets swept into the ban regardless of its brand name, an approach that casts a wider net but has generated its own controversy over whether cosmetic features unrelated to actual lethality should be the basis for a ban at all. New York and Illinois both rely heavily on feature-based tests. Maryland and D.C. combine a named model list with a feature test, giving prosecutors two separate paths to establishing that a specific firearm is covered. Virtually every one of these states also separately restricts magazine capacity, typically capping magazines at 10 rounds, which functions as its own distinct restriction, even in states where the rifle itself might not be banned outright, meaning a state could theoretically allow a specific rifle platform while still restricting how many rounds any magazine used with it can legally hold. The grandfather clause question is where most of the real confusion and most of the real legal risk actually lives for gun owners in these states, so it is worth walking through carefully. Nearly every one of these states allows you to keep a covered firearm you legally owned before the ban's effective date, but the specific rules for what you can do with it afterward vary significantly and matter enormously. In some states, like Maryland, a pre-ban firearm can still be transferred to another resident of that same state under specific regulations, preserving at least some in-state market for grandfathered items even after the ban's effective date. In others, including Virginia's brand new law, the item is frozen entirely. You can keep it, but you cannot sell it, transfer it, or pass it down within the state going forward, which effectively turns every grandfathered firearm into a dead-end asset the moment its current owner can no longer use it. In Illinois and Connecticut, some grandfathered items require formal registration within a specific window after the law took effect, and missing that window can turn a previously legal firearm into a felony-level possession charge overnight. Even though nothing about the firearm itself changed, only the paperwork deadline passed. A genuinely harsh consequence for what often amounts to a missed administrative step rather than any intentional violation. This registration requirement is exactly the kind of detail that trips up otherwise careful, law-abiding gun owners who assume that simply owning a firearm before a ban's effective date automatically protects them indefinitely, when in several states the protection is conditional on completing a specific bureaucratic step within a specific window that closes and does not reopen. If you live in any of these states and are not certain whether your own firearm is properly registered or grandfathered correctly, this is worth confirming with your state's specific requirements directly, rather than assuming a general rule from a different state applies to you, since the consequences of getting this wrong range from a simple compliance fix to a felony charge depending entirely on which state you happen to live in. Let's talk about the states where this is currently the messiest, because two of them deserve special attention given everything happening in real time right now. Virginia's new ban is the most legally unstable of the entire group at this exact moment. Multiple lawsuits, 4 separate state cases plus a federal case plus a Department of Justice lawsuit filed the very day the law took effect, have resulted in court injunctions that currently block enforcement across a meaningful share of the state, meaning the law exists on paper but is not actually being enforced against anyone right now while the litigation plays out, likely for another 6 to 8 months at minimum, according to attorneys representing plaintiffs in the case. Because Virginia's state police superintendent was specifically named as a defendant in one of these lawsuits, the practical effect of that single injunction reaches well beyond the county where it was filed, meaning state police currently cannot enforce the ban anywhere in Virginia, not just in the specific jurisdictions covered by each individual lawsuit. Maryland sits at the other end of an interesting spectrum. Its ban has already survived a direct federal court challenge in a case called Bianchi versus Brown, upheld by the Fourth Circuit Court of Appeals after years of litigation, making Maryland's law one of the more legally tested and currently secure bans on the entire list, at least until the Supreme Court's ruling in Viramontes potentially overrides that circuit-level precedent entirely, since a nationwide Supreme Court ruling would supersede any individual circuit's prior conclusion regardless of how well established that circuit's own precedent currently is. Beyond the states that ban entire rifle categories, there is a second, broader restriction worth understanding separately, because it actually touches more states than the assault weapons bans do. Roughly 13 states currently restrict magazine capacity in some form, typically capping magazines at 10 or 15 rounds, and this list overlaps with, but is not identical to, the states with full rifle bans, meaning a state can appear on the magazine restriction list without having anything resembling a comprehensive assault weapons ban at all. Colorado is a useful example here, because the Department of Justice has separately sued Colorado specifically over its magazine restriction, distinct from any rifle ban, arguing under the same constitutional framework that magazines themselves qualify as protected arms under the Second Amendment, an argument that, if it ultimately succeeds, would apply the exact same common use and historical tradition logic being used against rifle bans to an entirely different category of restricted item. If that argument eventually succeeds, either through the Colorado case specifically or through Viramontes itself setting a broad enough precedent, the ripple effect would reach every one of those 13 states with a magazine restriction, a genuinely larger group than the states with comprehensive rifle bans specifically, meaning the magazine question may ultimately prove to be the more consequential legal fight, even though it currently receives less attention than the higher-profile rifle ban litigation. Let me clear up a few more claims circulating alongside the inflated 19 states number, because they tend to travel together and reinforce each other. The first claim is that these bans are all identical, copy-pasted versions of the same law across every state. They are not, as we just walked through. The specific mechanism, named model versus feature-based, the grandfather rules, and the magazine thresholds all vary meaningfully state by state, which means advice or news about one state's ban does not automatically apply to another state's law, even when both get lumped together under the same general assault weapons ban label. The second claim is that any pending litigation automatically means these laws are about to be struck down imminently. That is not accurate either. Maryland's ban has already survived direct federal appellate review, and states like California, Connecticut, and New York have similarly defended their own laws successfully in court multiple times over the years, meaning the legal outlook varies considerably from state to state depending on that state's own litigation history. Not a single uniform trajectory toward these laws disappearing. The third claim, the one underlying that original inflated title, is that some dramatic court ruling already happened and immediately outlawed a specific list of firearms nationwide. Nothing like that has occurred. The only relevant Supreme Court action so far is a cert grant, an agreement to hear a case, not a ruling, and treating a cert grant as if it were already a final decision is exactly the kind of error that produces a headline detached from what the underlying court filings actually say. So here is what I would actually do with this information if you live in one of these states, or you are simply trying to separate fact from an inflated headline. First, if you live in California, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, Washington, Colorado, Rhode Island, Maine, Virginia, or D.C., confirm your own state's specific grandfather and registration rules directly through your state's own official channels, not through a general summary video, including this one, since the specific deadlines and registration requirements genuinely differ state by state in ways that carry real legal consequences if you get them wrong. Second, understand that nothing is currently more settled or more at risk today than it was before June 30th. The cert grant changed the timeline toward a final, nationwide answer. It did not change any current law, so treat every one of these state bans as fully enforceable today exactly as it was the day before the cert grant, with the single specific exception of Virginia's law, which remains blocked by active injunctions in multiple jurisdictions. Third, Mark your calendar loosely for oral argument this fall and a ruling by next June. Because that ruling, whichever way it goes, is going to be the single most consequential piece of information for every one of these state laws simultaneously, likely rendering most of the current state-by-state litigation moot or dramatically simplified the moment it comes down. Fourth, if you are a gun owner considering a move between states or simply traveling with a firearm through a state you do not live in, understand that possession laws in this area are notoriously unforgiving of good faith mistakes. A firearm that is perfectly legal in your home state can become a felony the moment you cross into one of these 14 jurisdictions, and ignorance of a specific state's law is generally not treated as a defense. Step back and look at the actual state of this issue heading into the next year. This is not a story about guns suddenly becoming illegal in 19 states because of a court ruling that never happened. It is a story about somewhere between 11 and 14 states plus D.C., each with its own specific version of a restriction that has existed for years in some cases and mere weeks in others, each built on a different combination of named model lists, feature tests, and magazine caps, each with its own separate grandfather rules and its own separate litigation history, all of them now waiting on the exact same nationwide answer from the Supreme Court, an answer that is coming on a real, verifiable timeline sometime before next summer. That is a genuinely more complicated and genuinely more interesting story than a single inflated number and a fake ruling, and it happens to have the advantage of actually being true, which matters if you are the one who has to live under whichever version of these laws currently applies to you. If this helped you get the real number instead of the inflated one, hit like so it reaches people who saw the other version of this title first, the one with the wrong number and the ruling that never happened, and subscribe if you have not, because I will be covering the actual Viramontes ruling the moment it comes down, along with every meaningful development in Virginia's ongoing litigation and the Colorado Magazine case between now and then. This is a story with a real scheduled endpoint, not an open-ended one, and I intend to walk through the actual ruling section by section the day it is released, the same way I have covered every other major development in this space this year. Tell me in the comments which state's specific law you want broken down in more detail next, because that tells me exactly where to go deeper as this story continues to develop over the coming months, whether that is your own state's registration deadline or how one of the currently pending lawsuits is likely to resolve before the Supreme Court even weighs in.